Good morning, everyone, and welcome. Thank you for taking time out of your schedule to join us for today's webinar, Opportunities for Increasing Rents under the Current Rent Regulations. Today's event is sponsored by Buildings New York and the Habitat Group, publishers of legal compliance resources for landlords and property managers, including the monthly newsletter, New York Apartment Law Insider, the monthly case digest, New York Landlord v. Tenant, the annual guidebook, NYC Apartment Management Checklist, and the New York Regulation Checklist. Join them and visit them at their exhibit at this year's annual gathering at Buildings New York, Pier 36, September 14th and 15th. If you haven't already, please register today at buildingsny.com. and join us for the largest community gathering of multifamily property managers, owners, staffs. We can't wait to see you. Now we'll begin our program. A little bit about our host, who will introduce today's speaker. Heather Stone is executive editor of the Habitat Group, publishers of legal compliance resources for New York City landlords and property managers. Heather, thank you for joining us today.
Thank you so much, Ed, and thank you to Buildings New York for letting us present this program today. Before I introduce a speaker, I'd just like to let everyone know we'll have slides for today's presentation, and we will be sending them out afterwards. Within a day or two of the webinar, you'll be receiving a link to the slides and a link to the video of this webinar. We have a lot of information to get through today, but we'd like to leave some time at the end for questions. Please put your questions in the Q&A section of the Zoom screen, as opposed to the chat section, because I'm much more likely to see them in the Q&A section. Okay, now I'd like to introduce our speaker, Eileen O'Toole. Eileen is the principal of the law office of Eileen O'Toole and counsels owners, lenders, and prospective purchasers of residential properties on rent regulatory and other housing issues. She also appears before courts and the DHCR in all phases of landlord-tenant litigation. She is the author of the New York Rent Regulation Checklist, a comprehensive guide to rent stabilization and rent control published by the Habitat Group. The Rent Regulation Checklist is now in its 4th edition, which will be available next month. And yes, you'll be receiving information on how to get a copy. And also, please come visit us at our booth at Buildings New York next month, September 14th and 15th at Pier 36. Eileen, I'll let you get started while I queue up the slides.
Okay, thank you, Heather, and thank you, Ed, for this opportunity to speak with everyone today. I'm going to cover 5 areas where there are rent increases available. As many of you probably realize, since HSTPA 3 years ago, it is much more restrictive what can be collected, but there are some things out there, and there are a few things that people maybe aren't even aware of. And if we have some time at the end, Heather and I will talk a little bit about just some recent cases and statutory developments of interest, just in a more general way. I have just finished up the 4th edition revisions for the rent regulation checklist, so a lot of these things are fresh on my mind at the moment. So Heather, maybe you can also help me keep track of time as we go along here. So, okay, that was the overview. We can move on to the first topic, which is individual apartment improvements. And as many of you probably know, before HSTPA, there wasn't any limitation on what could be collected. But you did have to maintain proof of the work if there was a challenge to a rent increase that resulted. And under HSTPA now, any rent increase for an individual apartment improvement or IAI is not a permanent rent increase. It's temporary, can only last 3 years. And there is an aggregate cap on IAIs. And I know I get questions about this sometimes from some of my clients, so I realize it may not be entirely clear. If today you did improvements and cost $15,000, you can collect those. You can collect the increase for those. But that has used up your $15,000 for the next 15 years. If you spent $5,000 today on an increase and spent another $5,000 5 years from now and another $5,000 a few years after that, that is also okay. But if you reach the $15,000 cap within 15 years, you can't collect any more money for IAI increases. The result of that, if you, I did work out when this first happened in 2019, what does that mean? If, IAI increases are generally either 1/40th of the cost or 1/60th of the cost, depending on how big the building is. And if you get a 1/40th increase on $15,000, what you can add to monthly rent for that is $89.28. Before HSTPA, you could collect $375 as the rent increase for that. So it's very restrictive. The law was also amended to add a number of provisions that may sometimes have come up as questions in the past, but now they're in black and white. IAIs have to be completed by a licensed contractor. And going to the next slide, you won't be able to collect IAIs if there are outstanding B or C violations, hazardous or immediately hazardous violations at a building. This was always true for occupied units. You can collect IAIs if the tenant agrees to them. The tenant has to agree in writing, and now there is a form for use for that DHCR has on its websites. And there can be no common ownership between the landlord or the building owner and a contractor who does the IAIs. In the past, before HSTPA, that would be something that might have triggered scrutiny, but now it is just simply forbidden. One of the things that has developed since the HSTPA amendments went into effect is that you have a number of ways that you have to document the IAIs. Previously, there were always DHCR policy statements or operational bulletins that explained what was required to prove IAIs if they were challenged, and that got increasingly more complicated as time went by. But basically, at this point, you should save as much documentation as you can. Have before and after photos. Have a contract or an agreement setting out what the work is going to be. Have the work itemized that you're going to do. Have canceled checks. If you pay in cash, you're going to have to prove how you made the payments in cash. DHCR will ask for bank records if there's a challenge to the IAI increases. But what you have to do initially, if you have a new tenant coming in and you've done IAI improvements, the DHCR rent stabilization rider that's supposed to go with all leases has several pages where you check off boxes and outline the work that was done, and it's fairly itemized what's done there. And the tenant has a right within 30 days, within 60 days, to ask you to see the documentation of the work that you say was done. And then the owner is supposed to have 30 days after they get the request to show the tenant that documentation. And the rider and DHCR says if the owner doesn't do that, the tenant can file, a incorrect renewal lease complaint, and DHCR will tell you to produce the documents. The other thing that has happened, and this started about 2 years ago in June of 2020, is there is now something called Individual Apartment Improvement Notification Requirement. And that is something that has to get filed through DHCR's ORAA system. Some of you may use that to do rent registrations, annual rent registrations. So the system, there's a lot of Q&A and instructions in that ORRA system online that can explain more to you about that. But the information about your IAIs is supposed to be provided to DHCR there, and then it gets incorporated into your annual rent registration information, for how much IAI increase can be added. So there are just a number of restrictions and requirements to document individual apartment improvements that did not formerly exist. Okay, I think we'll move on and talk a little bit about major capital improvements. MCIs are still available. They also have become much more restrictive. They are also temporary rent increases over a 30-year period. And the amortization period has been made longer. If a building has 35% or fewer rent stabilized tenants, you can't collect MCI increases from the rent regulated tenants. DHCR is supposed to audit and inspect about 25% of MCI applications. There's an expansion of the prohibitions against collecting MCI increases where you have immediately hazardous violations. And there are now caps. There are even larger caps or smaller caps, depending on how you look at it. Used to be, for rent stabilized tenants, you could collect only up to 6% of the rent that was in effect when you filed. That could be your MCI increase that would just get spread out over time and continue to get spread out until you collected it all. Now that's reduced to 2%. So, and there's no more, for rent stabilized tenants, you used to get a retroactive increase, but there's no more retroactive increase anymore. One of the things that HSTPA said was that DHCR was supposed to develop a reasonable cost schedule for MCIs. That was new. DHCR did start doing that in 2020 and has updated the schedule of the reasonable cost schedule every year. They did it in 2021 in January. They did it in 2022 in January. Yeah, Heather, we could be moving along, I think, on the MCI slides.
Okay.
But yeah, we're still, okay, I think you've been doing that. So, the reasonable cost schedule is there. It is applied by DHCR. I have wondered, I haven't seen it in any of my own cases, but I do wonder, and I suspect there are cases where owners may be challenging the reasonable cost for particular items. And I haven't seen any of those cases that may be coming up at the rent administrator level, with the district rent administrator. I haven't really seen PAR decisions on that yet. And there may at some point be some case law on that, but so far I haven't really seen anything. One thing, the DHCR has proposed some rent stabilization code revisions in connection with MCIs. There is information on DHCR's website about this. Again, DHCR has not issued any rent stabilization code amendments that could probably cover some of these things, although HSTPA said DHCR should do that by June of 2020. And so far, they still have not done that. MCIs is one area that there are a lot of materials available on the DHCR website. There are several fact sheets. There's information about seeking waivers, both for the reasonable cost limitation and for the useful life schedule. For example, if an MCI is supposed to replace something, the item's supposed to have a 30-year lifespan, and there's a reason that you need to file for a new MCI, even though you had replaced the item and received a prior MCI increase in less than the lifespan. There are opportunities to do those kind of applications, but you're supposed to do the application to waive the useful life before you actually file for the MCI. One of the things that I've seen come up in PAR decisions is that HSTPA got rid of group work as an MCI. Group work meaning, you replace all the kitchen cabinetry and appliances throughout the building. And group work is no longer considered an MCI. So there are cases where owners had filed applications for items that were group work before HSTPA came about, and then their applications for group work were being denied. And I think the PAR decisions have basically come down that if you were at the rent administrator level and you had a pending application, it was okay after June 14, 2019 for DHCR to deny an MCI for group work. But if it had already been approved and then tenants file a PAR appealing it based on HSTPA, HSTPA would not be applied because you already had a ruling on it. So again, with MCIs, the reasonable cost schedules are all online with DHCR. There's operational bulletins. There's the applications themselves are fairly extensive. There are a lot of supplements. There are a lot of instructions, and all of this information is available on DHCR's website. One thing I have noticed, DHCR publishes some kind of annual report, and the ones from the last few years have tended to show up on their website. And someplace in the beginning of the report, there's a section that shows the number of MCI applications that have been filed in recent years. And I have seen a drop, a noticeable drop in the number of filings of MCI applications since HSTPA went into effect. And I don't know how much the COVID pandemic may have had any effect on that, or whether it's all attributable to HSTPA. I guess, by the time we get to the next year or so, we may be able to figure that out more. So that's what I can tell you offhand about MCIs. And moving along, another thing I wanted to talk about today was substantial rehabilitation. And the rules about substantial rehabilitation of rent stabilized buildings haven't changed with HSTPA. But I have noticed just from writing the LVT digest every month that I do for Habitat, I read a lot of PAR decisions from DHCR. And there are a fair number of owners who are filing applications to seek approval of substantial rehabilitation. And there might be different reasons for that. And one of the things is there was never a requirement to file an application to have DHCR give you a stamp of approval on a substantial rehab of a building. The issue usually more often came up where you'd have an owner trying to evict an unregulated tenant, and the tenant would claim to be rent stabilized, and then you'd be in court, and the issue would become, was this building substantially rehabbed? And it would be played out in court, or the issue would come up if a tenant filed a rent overcharge complaint or a complaint that the landlord was refusing to renew the lease. So that then the issue would be, well, is the building subject to rent stabilization? And what substantial rehabilitation is, if you have a building that was rehabilitated after January 1st, 1974, it would become exempt from stabilization. And what substantial rehab consists of is outlined by DHCR in an operational bulletin. It's operational bulletin 95-2. This has been around for a while. It's still the same criteria. There are 17 items that they list, that they look for to see whether these items have been totally changed within the building or totally rehabbed. Now, some buildings may not have all of these. Elevators might be one thing, and you may not have an elevator building, but they are looking to see that 75% of the building systems were changed. The other thing that's an element of getting approval for substantial rehab is the building was supposed to be in substandard or seriously deteriorated condition when you started the work. That doesn't mean it has to be vacant. And sometimes sub-rehabs are done while you have a few tenants in occupancy. And if that happens, those tenants remain rent stabilized or rent controlled if they happen to be rent controlled, even after you've finished the work. It's after, once they move out, the apartment is exempt from rent stabilization. And if any tenants move into the building after the work is done, they're not subject to rent stabilization. The application for sub-rehab can be fairly, there's a cover form that DHCR has. You're seeking a quote unquote AD, or administrative determination. And you have to provide a lot of information, showing what was filed with DOB, showing if you got a certificate of occupancy or a letter of completion from DOB when the work was done, having an architect or engineer who was involved with the project preferably submit a description of what was done. Proof of the cost is they're usually looking for. And also, one thing that can hold up being able to exempt the building is if part of what the owner did was obtain tax benefits through the J51 program, for example. If J51 benefits were obtained after you did the work, the building became subject to rent stabilization, even if it wasn't, because it was sub-rehabbed, at least for the period of the J51 benefits, which could be 15 years. In some cases, it's over 34 years. So that can be an issue, but there are certainly owners who even at this point go back and are looking to get approval that a building was sub-rehabbed that was done 5 years ago, even 15 years ago. And one of the things that is out there in pending legislation, it hasn't gone anywhere, but I'll mention this again, connection with something else, but there was a proposed bill in the state legislature in June of 2021 that was going to require owners to apply for approval of a building they were claiming was exempt from stabilization because of substantial rehab. And I think that the proposed bill said, you'd have a year. If you did work in the future, after the bill was passed, you'd have a year then to file the application after you did the work. But if you had already done the work and the bill was passed, you had 6 months to file an application with DHCR. That bill didn't go anywhere, really. It was introduced in June of 2021, and it really never got out of committee. It's sat around, so I don't really know whether that's going to be revived or will come up again in the next legislative session. I think, I think a lot of people on both sides were spending a lot of time worrying about the good cause eviction bill, which did not happen either. So this kind of just stayed under the radar and nothing happened with it. But I have seen a number of substantial rehab applications being filed in the past couple of years. So moving along, another thing that is still a way for owners to get rent increases, and again, there has been talk of putting restrictions on it, is what we call creating new apartments. I think there was an article in Gothamist or one of those web news pages just yesterday talking about this issue. I think from the tenant advocate point of view, these are called Frankenstein apartments, which I don't hear too much. And it reminds me when I saw this that that there is reference to it that way. But creating new apartments has been an avenue for obtaining rent increases for some time. It's developed through case law. There is some provision for it in the rent stabilization code. And what it basically means is that you have, the simplest example, you have two adjacent apartments and they both become vacant, and you combine them into one larger apartment. That is a newly created apartment. You can set a first rent at what the market will bear. And now post HSTPA, that rent has to be rent stabilized. But then your guideline increases are based on that new apartment rent. Before HSTPA, if you created a new apartment, you took your two apartments, you combined them, and your new rent was above the deregulation threshold, that would be a deregulated apartment. In terms of combining apartments, it also goes the other way. It's not just that you can take two small units and make them into one big one. If you take one big apartment and convert it into two adjoining apartments, that is also a creation of a new apartment. There have been cases over the years where, has enough work been done to qualify as having created a new apartment. If you basically, move the closet from one apartment to the apartment next door, that's not going to cut it. And if there's a challenge, there would be a finding that it's, not a newly created apartment. Sometimes people ask, do you have to have DOB permits and plans and filings and approvals to create a new apartment? DHCR generally has not been so concerned about that. If otherwise you prove that the apartment was newly created, by combining or discombining apartments, they have permitted that. And if there are any complaints along the way in the process that, it didn't get proper approval from DOB, this wasn't done or that wasn't done, DHCR often will say something to the effect of, that's outside our jurisdiction. If there are issues about whether you complied with DOB guidelines or regulations and doing this work, you have to go complain to DOB. That's not our concern at DHCR or anything that we have authority to rule on. So creating new apartments is still there. The DHCR operational bulletin I mentioned, I give you the citation for it to find it. I mentioned it when I was talking about substantial rehab. There's a paragraph that talks about creating new apartments in there also. Creating new apartments is another issue that is the subject of pending legislation. The same state Senate bill that was introduced in June of 2021 that just hasn't really gone anywhere. There is language in that bill that amends the rent stabilization law to restrict how rents can be set if you create a new apartment. The language, I have it in my slides, but the language is to the effect that if you had a large apartment and the rent was $2,000, if you split it in half and created new apartments, the base rent for either of those apartments would have to be $1,000. And otherwise, if you created a new apartment that was larger, you'd have to combine the rents of the prior two apartments to set the new rent. So that hasn't happened yet. I don't know when it may happen. Obviously, any of you who are involved with organizations like Buildings New York or other landlord groups will likely get fairly regular information on what's going on in pending legislation and rules from these groups. But if you're someone who follows what goes on in Albany in terms of pending legislation, this is something you may want to keep your eye on, and people have been keeping their eye on for some time. The tenant advocates, as recently as yesterday in an article that I saw online, are complaining that nothing has happened. It was supposed to happen, and the government is still letting landlords get away with making Frankenstein apartments. One thing that could happen in addition or alternatively to Albany doing something is that you could have DHCR, if they get around to making amendments to the rent stabilization code, the regulations under the law, they could try to put something in the rent stabilization code about this. But so far, that hasn't happened either. So finally, the last thing I'll talk about in terms of opportunities for increasing rent is something that it sounds a bit arcane, and it is something that exists. I see it come up more often in circumstances where you have rent controlled apartments that didn't get increases for a lot of years, but it is also in the rent stabilization law and is something that can be applied for. The presence, what they say in the rent stabilization laws, the presence of unique or peculiar circumstances materially affecting the initial rent, and that results in a rent that is substantially different from the rents generally prevailing in the same area for substantially similar housing accommodations, can be a grounds to ask the HCR to increase the rent. And over the years where I have seen this come up more, I just tried to give you a couple of case examples here. Sometimes, I've seen this scenario more than once. You have a building, someone lived in there who was the prior owner's family member or friend. They got a sweetheart deal on a lease for a long time. They may not even have paid rent, or they paid a very low rent and no one ever increased their rent. No one ever bothered to file MBR increase applications every year for a rent controlled apartment, not because they were violations, just because they just were friendly with someone or it was too much trouble for them to do it. So new owner comes along and you've got an apartment, you have a fair sized apartment and the rent is like $250 a month. And it just seems out of whack with everything going on in the vicinity for that size apartment. You can apply to DHCR. You can make your argument as to why you should get an increase for unique and peculiar circumstances. And sometimes that works. And sometimes you get a rent increase because of that. And, there's one case I cite on the second page here, that this 207 Realty, they just say the purpose of it is to bring rents that are artificially depressed in line with similarly situated housing accommodations. And one thing DHCR has information on that they can look at, or you can ask to look at yourself if you have one of these applications, is there is information of rents by zip code, like the average rent for, say, a 2-bedroom apartment that is kept by DHCR for use when they have to set rents under the default method in overcharge situations. So that information is available. You can ask DHCR for information, what's the rent, the prevailing rent for a 2-bedroom apartment in zip code 10013, for example. And that may be one of the things they look at in considering what to do. I had a case that I was involved with recently that I mentioned here just because, again, it was a case where, at least for today, we have a favorable ruling from DHCR. It is under appeal, but I think there's language in here that the DHCR would uphold. It was a case where someone was converting a building back in the 80s and had some tenants in the building that they were trying to negotiate with, and basically gave a tenant a $300 a month rent for a large unit in forever. There was no rent increase provision. And then at some point, through some other litigation, it became clear that the apartment was subject to rent stabilization, and the rent was still sitting there at $300 a month. And a new owner bought the apartment and applied to DHCR and did get the rent increased. It's still, under $1,000 a month, but it was, given that the base rent was $300, was fairly significant. And one of the things that the DHCR, the rent administrator, noted was that, you've got a lease, it's rent stabilized, the prior owner's not even there anymore, and having a rent stabilized unit where you have to waive your right to a rent increase forever is unenforceable as a matter of public policy. Now, that is consistent with a lot of DHCR decisions and court decisions that have gone the other way, that, tenants can't waive their rights under rent stabilization. And sometimes if they have, through court stipulations, there can be future litigation where that gets upended by another court saying, that was against public policy, whatever you did. So this at least consistently applies the law and gives owners some opportunity to get rent increase in unusual circumstances. So I don't know, Heather, if we've had...
It's about 10:35, so we have some time here before we get to questions, if you want to go over some of the recent news here.
Okay, just to note a few things that you may know about, and these things are things that between writing the LVT case digest every month and being a landlord tenant attorney and writing the rent regulation checklist, some of the things that are of note, the Rent Guidelines Board, probably most people know, guideline number 54 takes place on October 1st. And it's higher guidelines than we've had in a while, 3.25% for a year, 5% for 2 years. And what I would think everybody is happy about is that you don't have any like split year. It was, I don't know, I think it was a little confusing enough when you had a 2-year guideline that, was 0 for the first year and 2% for the second year or something like that. But when last year you were splitting a 1-year guideline increase, so for 6 months it was 0 and then it was a very low percentage. I just think that must have been an administrative nightmare for any management company. It could have been an administrative nightmare for tenants paying rent and wondering how much their rent was this month. I'm sure it was built into the lease forms and the rent registrations how it would be handled, but it's still probably created some kind of confusion. So that, at least, there's higher guidelines and it's simpler this year. The big news upstate in the past few weeks is that the city of Kingston has adopted rent stabilization under the ETPA. Now that is something that was in the HSTPA also, that it allowed for more communities outside of Nassau, Westchester, and the 5 boroughs to adopt rent stabilization. And it was based on a vacancy survey, however that was done. I think there are owners up in Ulster County in Kingston who are concerned that the vacancy survey wasn't done properly. And I wouldn't be surprised if, some lawsuit challenging these new ETPA provisions in Kingston go into effect. But in the meantime, rent stabilization now applies in the city of Kingston, and there was very quickly I'm told that the DHCR sent out information to the owners of rent regulated buildings that initial registration of apartments is required within 60 days. And, the paperwork has been sent to them. I also heard that a rent guidelines board has been set up now already so that they can start setting renewal increase rates up in Kingston. And, I wouldn't be surprised if there are several challenges that come through, but there will also be a lot of owners scrambling to get into compliance and to figure out what avenues they may have for seeking exemptions from rent stabilization while they're waiting to see if the lawsuit has any legs. So there may be other cities and communities in New York that are also considering adopting rent stabilization offhand. I'm not sure. I don't know if Heather knows of anything, but this
I
was.
think tenant advocates are trying to get vacancy surveys done just to see if maybe they can get something going in their cities. Yeah.
So, so that was big news. The law passed at the end of July, and it went into effect August 1st of this year. And as far as housing court, this webinar isn't really about housing court issues. We're really focused on rent stabilization and rent control. But I will mention, just because I see so many motions made and decisions on it, is that while the eviction moratorium has went away January 15, 2022, there's no more eviction moratorium Occasionally, you might have the fact that a tenant filed a hardship declaration some time ago. That may still have an effect in some housing court cases, but where things have really shifted to, particularly in non-payment cases, is whether the tenant is seeking ERAP assistance, payment to the landlord directly of rent that accrued during the COVID pandemic, and that, the need arose because either directly through being sick or through having financial issues that were related to, whatever was going on during the pandemic period, the tenant hasn't been able to pay the rent. And the ERAP program can provide up to 12 months of rent, with another 3 months going forward. When they grant an application, the money goes directly to the owner. That's assuming the owner will accept the ERAP money. There are some cases, if it's an unregulated apartment and the owner doesn't want to have to continue a landlord-tenant relationship with the tenant, they may have a basis to refuse accepting ERAP funds. There have been several points in time after ERAP came into effect where the money just dried up and the applications would sit there, but they weren't being processed because there was no money. So one of the things, the law providing for ERAP provides for an automatic stay. So if the landlord is notified that the tenant, or sometimes it's an occupant or a licensee, has applied for ERAP payment of rent, a case won't proceed, or you're not even supposed to start a case if you've gotten notice that the ERAP application is pending. And you'll get notice from the state OTDA, the office that processes the applications. So there have been many, many motions made in housing court certainly within the past 3 to 6 months, where owners are asking courts to vacate the ERAP stays. And the results are mixed. Sometimes you'll have judges who will say, statute clearly says there's a stay of the proceeding while the ERAP application is pending. Sometimes it's clear that the ERAP application isn't going to go anywhere. For example, someone who was the building super, who is now, the owner is seeking eviction because the employment was terminated and they're not being accepted as a tenant, that person will file an ERAP application, but that person hadn't paid rent. So there's not going to be any reason for them to get ERAP because they didn't pay rent while they were living in there as an employee anyway. So owners in a case like that may be able to get the ERAP stay vacated because it's not going to go anywhere, and it would be an exercise in futility to go with that. So there's a lot of the decisions are interesting, and they may be informative for people. And I will say, just to give Habitat and LVT a little plug, I mean, that LVT is one place where a lot of those decisions have been summarized and are certainly of interest. One other thing I'll mention, I think I wrote this up for LVT recently too. We talked about, I think before we started, we were talking about the good cause eviction bill that has not gone through at the state level. But the city of Albany passed its own good cause eviction bill within the past year. I forget exactly when it happened, but a lawsuit was commenced and the owners won. It's probably under appeal, but the court found that the good cause eviction bill for unregulated tenancies was inconsistent with a lot of provisions of the RPL and the RPAPL. And there was a fair amount of discussion in that decision of why this court was deciding that it was not, it was not a legal or constitutional thing to do in light of the other laws here. So there may be other areas where good cause eviction, other towns or cities where good cause eviction may be passed that may end up with some lawsuits like this too. So
Do you think Albany will take it up again for statewide good cause eviction?
I'm not sure what happened with it at the end of June 2022, but it seems to be the hot issue for the past couple of years. It doesn't seem ready to go away, but the state legislature takes up again really in the fall. So we'll have to wait and see what happens then.
Okay, well, I've put up some resources here, websites that folks can go to for more information, including, as Eileen mentioned, New York Landlord v. Tenant, our monthly case digest, New York Apartment Law Insider, and the new edition of the Rent Regulation Checklist is coming out next month, which Eileen wrote. And I'm going to stop sharing. I'll remind everyone that you will get a copy of the slides. Let's see, pause share, stop share. There we go. Got it. Okay, let's get into some questions. I have one right off the bat that I think is going to relate to another question someone else has. You mentioned that tenants can challenge IAI rent increases. And let's say tenants are in residence and they're not a new tenant. They've been there, they've had the improvement. Are you seeing any cases like that as the editor of LVT? Do you see cases like that where tenants are challenging those rent increases, or are they mostly from new tenants coming in challenging improvements that were done before they became tenants?
There is a mix. There are some cases, and sometimes it depends on the facts. There are cases where a tenant will file an overcharge complaint or raise overcharge as a defense in housing court and say, and sometimes it comes up if they're deregulated, and sometimes they're not deregulated. They'll say, I've been overcharged, and part of the reason I've been overcharged is that the landlord collected IAI increases, and sometimes it's more than the 4 or 6 years ago. And this was the result of fraud, a fraudulent, attempt to deregulate the rent. And therefore, the DHCR or the court should break down the wall, the 6-year statute of limitations, and look at the rent. Now, DHCR or the courts, you can challenge whether an apartment was properly deregulated more than 6 years ago, and DHCR will ask owners to produce documentation showing how an apartment got deregulated, but it doesn't always go anywhere. Sometimes they will just say, look, it's too old to, especially if it's simply an overcharge claim, it's too old to look at what happened 15 years ago. And if you want us to look at what happened because there's rent fraud, a rent increase by itself isn't enough. The rent went from $750 to $1,500, and whether you have IAIs that support that is one question. But whether or not you can say that in and of itself is fraud, DHCR is more likely to say that it's not. So it's not impossible to do, but it's more difficult to simply challenge IAIs, because they were old, especially if it didn't result in deregulation, of the apartment.
Okay, someone asks, if a unit is rent stabilized and recently vacated after a 50-year tenancy, and the unit needs a gut renovation, improvement costs would be in excess of $50,000. Could the landlord rent the unit at rent stabilized cost, or I suppose rent, and allow the new tenant to improve the unit at their own expense?
I think that I have heard that question before, and I think that there are owners who consider doing that. I would be careful. And again, I think it depends on the facts, that it could be deemed to be, something done to evade the system, and DHCR or a court might not look well upon this. I think, on the other hand, there could be instances, real life instances, where the work, $15,000 worth of work has been done to give someone a new but kind of bare bones kitchen, and the tenant really wants something more than that and is willing to pay for it, and the owner will agree to it. If you're doing something like that really involves putting fixtures into a unit, like if you screw in new cabinets or new shelving into an apartment, that always was something that would be considered a fixture. And you weren't really supposed to be taking it out when you left because, one, what are you going to do with it? And two, removing it can cause more damage than just leaving it there. So, imagine part of an agreement like that would be that, you can do the work, we'll permit you to do the work. You have to, follow whatever rules there are to keep the work safe and legal, what you're doing. But, if you're putting in new cabinets or things, you've got to leave them there if you move out. Now, could DHCR or court have questions about? There could be questions about that. I don't
the
think
landlord would then be responsible for maintaining whatever was improved upon for the next tenant too. Like
That's true. If it's left in there, that's right. It would then become, that's right. If what was added in is left in the apartment, then it becomes something that the landlord's responsible for maintaining. Like, say that included a dishwasher, or a little washing machine, that sometimes can be put into newly renovated apartments, the kind of things people would be likely to look for, or an air conditioner, that the prior tenant put in but left behind, and you left it in the apartment. Then it's your responsibility. Then it's part of the required services because it's something you're providing to the rent stabilized tenant. That's right.
right. Okay, when filing for a unique or peculiar circumstance, I assume the apartment should remain vacant until a decision is given. Can be a year or longer before receiving a decision. You can file that even when someone's in the apartment, right?
Yeah, because that's the point of unique and peculiar circumstances. I'm sorry if I didn't make that clear. The point of it can be, and in that last case I mentioned, that I was involved in the case, the tenant is there. That's the point. The point is the tenant's there and paying $300 a month and is not going anywhere. And the point of the exercise and the application is to get a rent increase for the tenant who is living in there. So you don't have to wait for an apartment to be vacant. Yes, granted, DHCR in a lot of things is still fairly slow. I know the application that I had filed based on unique and peculiar circumstances took over a year, to get a result. I mean, it was during the pandemic period, but it also, there are many overcharge cases that sat for a long time before COVID ever came around. I don't know how much better DHCR has gotten on their timeline of issuing decisions.
Okay, someone writes, I'm a commercial broker and I represent a building which is for sale that has 6 residential units that are stabilized. 7 of the units are not occupied and have not been throughout the renovation. Now that the building is for sale, where can a potential buyer best understand the stabilized, not stabilized after renovation? The approximate cost of the renovation was $1 million. So
Okay.
it looks like they are occupied. Some of those units are occupied. So.
Yeah, but I'm not sure what the question is. I don't exactly understand the question.
Oh, I suppose that, okay, some of the units were not occupied. I suppose a question is if they weren't occupied and they went through a renovation, then are they stabilized or not stabilized after the renovation? I guess it would depend on the particular, you'd have to have more information.
If it's today, if it's after June 14th, 2019, any renovated apartment, no matter whether it's fancy schmancy or bare bones, every renovated apartment in a rent stabilized building is rent stabilized. Even if you, assuming you lawfully collect the rent. I mean, what rent you set if the apartment's been vacant for a while, and if, you can't increase, if you haven't changed the parameters of the apartment, you haven't created new apartments, even if you spent $50,000 per apartment on the vacant units, you can't collect more than $15,000 in IAIs. The units are still rent stabilized. If you change the parameters enough to create new apartments, you might be able to, just charge first rents for newly created apartments. But if you did work to half the building, but it's not a building-wide substantial rehabilitation, you're not getting the building exempt from rent stabilization either. So I'm not sure if there's a more precise question buried in there, but I don't know what else you can do with those units. Yeah.
Okay, well, I think we have time for one more question. Okay, how do you think DHCR would set the rents if a landlord were purchasing a building from a religious organization and the apartments were previously registered as permanently exempt? The religious organization is vacating the building upon the sale. Would the units be free market, or would the first rents be rent regulated?
That's a very complicated question.
Complicated.
I can answer in this context.
Too much going on in that one. I'm sorry.
There's too much going on, so it's impossible to give it's impossible probably to give a right answer. So.
Okay, I think that's probably all the time we have. I'm sorry, we did a bunch of questions, but we did the best we could. And thank you so much, Eileen, for speaking today. And thank you everyone for attending. We will be sending a copy of the slides to everyone, as well as a link to the video as soon as it's available. And thank you, Ed.
Great. And Heather, Eileen, thank you both. Wow, that was just incredible insights. And I want to thank each and every one of you who joined us today. Be sure to join us next Tuesday when we'll have an entire session at 10 a.m. on Buildings New York Unlocked, where you'll be able to understand how you can increase rents by creating more rent opportunities through experiences for your tenants. You can register at buildingsnewyork.com and also join us on September 14th and 15th for Buildings New York and our annual gathering. Thank you, Eileen. Thank you, Heather. And thank you, everyone who joined us. Bye-bye.
Bye-bye.
Thank you.